Thank you, Dean O'Neill, and thank you all for coming out tonight. I wanted to say what a joy it is to be here in Belfast for the simple reason that I consider myself Irish by marriage. You see my wife with her unmistakable red hair, Mary Christie Fisher. Her family is the McNamara's from Knock County, Mayo on the one side, and the O'Hagans from Armagh on the other side. And hence my son, William Hagan Wanlimco, is named after the family in Armagh. And my daughter, Emily Coe, on the far right, also with red hair, was originally named Mairead until we found out that no Korean could pronounce Mairead. That's Hillary Clinton, but she has nothing to do with this story. I'll also tell you a funny story, which is on the day that my wife and I got married, one of her Irish relatives came forward and said, "You know, this is a mixed marriage." And I said, "Do you mean because I'm Korean and she's American?" And he said, "No, no." And I said, "You mean because I'm Methodist and she's Catholic?" And he said, "No, no." He said, "Her family is from North Ireland and also South Ireland." And I said, "Well, that's okay, because my father's from South Korea and my mother has relatives in North Korea." And he said, "Okay, then we're okay. Then we're okay." So this is one reason why I'm thrilled to be here in the land of Kenneth Branagh, Mairead Corrigan, Mary McAleese, C.S. Lewis, George Best, and of course, Van Morrison. And I will say it's a wonderful night for a moon dance. I'm especially joyful to see my dear friend of decades now, Chris McCrudden, who is one of the great human rights scholars of the world and has been a friend of mine for many years because of our mutual connection to the Yale Law School. And he was the one who was kind enough to invite me here today. I admit that part of my motive is that I'll now have a chance, having been here once, to return with my wife, and we'll go up to Armagh together to check it out. I'm also very thrilled to be here as part of the launching of this institute in this place in which so much tragedy transpired, but an effort to rise above that through the use of law and a commitment to the rule of law. And it's that spirit I wanted to speak today. I spent 30 years in this business now, more than 30 as an international law professor, 20 as a human rights lawyer, 10 working in the United States government, 5 years as a dean. And the last 4 years, up until this January, I spent doing many things. On the top left at the UN Human Rights Council in Geneva, top right in Moscow with the president's party for the summit, bottom right, Guantanamo, where I've gone since 1991 on and off for various reasons. Bottom left, Afghanistan, on the left side, Iraq. The middle, Greece for the financial crisis. Far right, South Korea, where I attended the funeral of the Nobel Prize winner Kim Dae-jung with Secretary Albright. And I appeared in many courts, the International Court of Justice in The Hague, on the left, the European Court of Human Rights in Strasbourg, the African Court of Human and People's Rights in Arusha, and representing the US to the International Criminal Court in The Hague. And I took many flights. This picture is the one that's the most famous. You may recognize it. We were going into Libya after the fall of Gaddafi, and they got us a military plane. But because Secretary Clinton needed a better seat, they gave us 4 seats in the middle, and I got to sit in one. Photographers then started taking our picture, and it's obviously embarrassing to sit there doing nothing, so we were all texting. So I texted to Secretary Clinton, "Look over your shoulder." And that's what she's actually reading in this famous text, which then became a meme text from Hillary. There are many issues that I worked on, those that arose out of the past, were from 9/11, particularly now the question of drones in Guantanamo. During my time in the government, Arab awakening, international criminal law, numerous human rights issues, and then many events which struck me as part of the future: cyberspace, environment, private international law, public health, food safety, and then a group of things that you would call acts of man and acts of God. WikiLeaks, which was an extraordinary trauma to the US system, millions and millions of documents being released that were supposed to be confidential. It was the equivalent of having all of your emails released for your entire life and then having a choice of whether you go back and apologize to people who read the emails and are offended or continue doing your other work. It's a massive diversion of energy. And then every once in a while there would be a natural disaster of the highest order. For example, devastating earthquake in Haiti, earthquake in Christchurch, New Zealand, earthquake, tsunami, followed by a nuclear meltdown in Japan, all of which took extraordinary amounts of time. Because we're in an academic setting, I want to contrast the role of government and academia. In academia, obviously, you're your own client. You don't have to consult with anybody else. You just say what you think is right. Here, my clients were Hillary Clinton, who's an extraordinary lawyer, Barack Obama, who's no slouch either. And the operative decision was theirs. The question that I had to decide was whether the policy decision that they wanted to make was lawful. And if it was lawful, it's their choice to make. Second, that you're a part of a huge team. I ran a law firm of 200 international lawyers, but in the US government, at the Defense Department, there are, anybody know? State Department has 200 lawyers. Defense Department has 17,000 lawyers. Then there is the CIA, there is the Director of National Intelligence, there is the Department of Homeland Security, there is the Department of Justice, which has tens of thousands of lawyers, there is the National Security Council, there's the Treasury Department, there's the Commerce Department. To get to a US government legal position can sometimes involve thousands of lawyers. Any speech I gave in the US government was cleared or read and edited by well over 200 people before I delivered it. Sometimes to the point where they were editing it while I'm sitting there waiting to be introduced. And people would hand me things that amounted to an agreed upon statement that could go into the speech. So it's not just you. What's valued, obviously in academia, is equality and freedom. In government, it's command and control, or chain of command, hierarchy. Academics favor originality. In government, the trick is to say that everything has been done before. And being original is extremely scary. In government, you say less. Academics say more. So when academics read government statements, they often say it's just at the point where it started becoming interesting, they stopped. And the reason is beyond that, they couldn't agree. Having opinions, every academic has to have an opinion about pretty much everything. In government, you're not supposed to have opinions, you're supposed to achieve results. And then facts. In academic life, academics often need to know the facts that is necessary to support their theory, and more facts can be inconvenient because they don't support the theory, so usually they stop. In government, the facts are critical, and often the facts are just accumulated to the point at a point where you think you know everything there is to know factually, you make the best decision you can under the circumstances based on common sense. So I think that the two things that struck me the most is that lawyers focus on issues, or academics focus on issues, whereas government lawyers actually have to deal with the issue, then the next issue, then the next issue, then the next issue. So it's the big picture, the interconnectedness that matter. So when someone's calling for humanitarian intervention in Syria, that's an issue. And whether there's a legal basis for doing a humanitarian intervention in Syria, the government lawyer is thinking, where are we in 5 years? What's the state of the government? Who controls chemical weapons in 5 years? Will there be accountability? Who will be the government of Syria at that point? Will you have ousted Assad by military force? Will he be given amnesty or not? In other words, the issue that may be driving action today is connected to dozens of other issues, and unless you've thought about the best answer to all of the issues at once, you shouldn't take step one. And then proportion. Much of my time in the government was spent dealing with advocates or academics who would come in and say, I happen to have spent the last 10 years writing about X. So what are you doing about X? And the answer is X is important. No doubt it's important. It just happens to be one of 100 important issues that are being addressed in a sequence, and so your issue will come about number 99, which is of course outrageous because for them, this is issue 1. And therefore, they have no sense of the proportion of the issue that they care about in the grand scheme of things. And then the biggest given about government service is what I'd call 2 guys from Galway. You all know this story, the 2 guys from Galway walking down the road, and then one of them says to the other, how do you get to Dublin? And then the first guy says, I wouldn't start from here. Well, you would like to be the legal advisor of the State Department, say at the founding of the UN. It turned out they've already founded the UN. So how about this? The worst economic crisis since the Depression, 3 wars, WikiLeaks release, 4 earthquakes, the worst political environment in US history. And you might say, I wouldn't start from here. But guess what? You don't have a choice. Any more than you have a choice to play the hand that's different from the one that you're dealt when you're sitting at the card table. So I played many roles as legal advisor. I was the managing partner of a firm of 200 lawyers, about 400 people. I was a counselor, the general counsel of the State Department, so we did things that the general counsel of this university would do. We bought buildings. They happened to be in Kabul. We obtained visas, but they happened to be from Iraq. I managed conflicts within the State Department, which is a very far-flung organization. But what brings me here today was that one of my roles, and it's a unique role for the legal advisor of the State Department, is to be the spokesman and conscience of the United States on international law matters. And it often comes into conflict with your job to be the defender. If the legality of US conduct is challenged in an international forum, the legal advisor appears to defend. That's why I was at all these courts. There is no other person to do it. And if you're not prepared to defend the legality of the policies, you should not be in the job. So I understood, for example, that it would require me to defend the legality of the death penalty. I despise the death penalty. I think it's a terrible policy. In my life, I've worked in many ways to eliminate the death penalty. But I also do not believe that the death penalty violates international law per se. I don't think there's a customary norm of international law that invalidates the death penalty. If the United States is challenged for the use of the death penalty by some states before an international forum, I will appear to defend the legality of that. If not, I shouldn't be the legal advisor. And I was sometimes asked, how can you defend something you don't believe? And the answer is, I never did. Why should I? I have tenure. I will never say something I don't believe, but I do believe that the death penalty is not illegal under international law. Now, this put me in an unusual position often, which is I consider myself a man of peace, a teacher of international law, a defender of human rights, but I was a lawyer for a nation at war. And that puts you into postures where you sometimes have to see the law through different dimensions. And so, for example, I was often asked, how as a human rights lawyer did you criticize torture but defend the legality of the use of drones? And my answer was, all torture is illegal, all killing is regrettable, some killing in wartime is lawful, but if you follow the laws of war, some targeting promotes human rights on balance. I believe that the targeting of bin Laden, whose job was to kill innocent civilians, and he killed tens of thousands in his lifetime, is a human rights promoting act. And so, because I'm not a pacifist, it's my inescapable duty as a government lawyer, applying the laws of war, to draw difficult lines between uses of force that are lawful or unlawful, and uses of force that are do or do not on balance save innocent lives. Now, that's a harder job to do, to police this painful line, than it is to be an absolutist. But I found, for example, that as a dean, I memorized the resumes of my students. And for the last 4 years, I memorized the resumes of al-Qaeda members. Because if we were going to target al-Qaeda members, I had to be confident that they were leaders in an armed conflict, which meant that I needed to know everything about them and make sure they were the right person, that if someone was, and I found in one case a senior leader was born on the same day as my own daughter. And I saw that on the day that my daughter turned 14, he killed somebody. On the day that my daughter turned 18, he led a suicide attack in which 3 people were killed. On the day that my daughter turned 21 and he turned 21, he planned an attack in the United States that got to a certain state. And it makes you understand that this is something that you don't want to do forever, because in academic life, you can look to students who have the highest aspirations. And in the context of the laws of war, you're often addressing people whose lives are tragically misshapen by circumstance. And that leads you to a dreadful set of emotional and ethical challenges. This led me to 2 recurring questions. The first is, I spent most of my life as an academic. Are these theories relevant? And then the second is what I call avoiding the tennis court problem. When you go to the government, it's like walking onto a tennis court and being given a tennis racket, and balls start to come over the net, and in the first couple of minutes, you try to return the balls. And at first it's very difficult, and then you get the pace, and you're returning almost all the balls, and then you start to realize I need to return them with a plan. So you start trying to hit them all to one side, the left side. Then you're very proud of yourself, you're returning most of the balls to the right side. And then suddenly you say to yourself, why am I not throwing the balls? Why am I being utterly reactive? If I were throwing the balls, would I have a strategy by which I'm addressing all these challenges? Is there a global legal strategy to address these 21st century challenges? In other words, do we have a plan, not just a set of reactions? Now, in academic theory, I had posited, and there's no need for you to know this, but just to give you a sense of where I was coming from, 2 basic ideas. The first, transnational legal process, that a combination of interaction, interpretation, internalization leads to norm internalization in compliance with international law. That American exceptionalism can be categorized as either positive, exceptional leadership, but also negative exceptionalism, which is the United States pursuing double standards. So the question is how to use US exceptional leadership to promote greater compliance rather than lesser compliance. And at a constitutional level, I've written about the need for checks and balances in foreign affairs. The key of my approach to transnational legal process, what I call interaction, interpretation, and internalization, which leads to the vertical domestication of international law. It's more simple than it sounds. If you want to know why nations comply with international law, most compliance is obedience, and most obedience is fostered by transnational legal process. So ask yourself, why do people now wear seatbelts or wear bicycle helmets or recycle? It's because they've, through a series of interactions and interpretations, internalized a norm of doing so, which makes their obedience compliance with rules. On American exceptionalism, I've already stated the basic proposition. how to promote positive exceptionalism while keeping negative exceptionalism within a margin of appreciation, and the National Security Constitution, how to maintain checks and balances. Now, since I offered these views, the world is somewhat different. We are in a post-Cold War world where both the Berlin Wall and the Twin Towers have fallen. We're in a flat age, as Tom Friedman would put it, of globalization, where there are many threats, actors, and decision makers. And we're in a uniquely toxic US political environment where international cooperation has virtually ended. Which raised the question how to define an international strategy to promote norm internalization, promote positive exceptionalism, and still be consistent with checks and balances. So that was how I set the task. And I would summarize my answer in 3 words: engage, translate, and leverage. I say this so you take this away if nothing else. That if there is an approach that the United States should adopt, and that I believe the UK should adopt going forward, it's engage, translate, and leverage. Engage with other countries around legal norms, translate 20th century rules to apply to 21st century problems, and then leverage the legal solutions with policy outcomes to achieve certain results, which cannot be achieved by global governance alone. This is what I call international law as smart power. Now, here's a more simple way to put it. Everybody knows that hard power, as Paul Kennedy would put it, led to the decline and fall of the great powers, that colonial powers like the UK, China, tried to use military force and economic might to control the world. That put them to a situation of imperial overstretch. They found themselves deeply indebted, militarily overstretched abroad. Their position was taken over by their successors, and they couldn't maintain their influence. So how do you maintain global influence if you no longer have hegemonic power? And the answer is to use your values and your moral leadership as a source of legitimacy so you can put together coalitions that lead, the so-called soft power or smart power approach. Now, I want to identify one key element of this, which is a blunt truth, is that most of our law is from the 20th century and most of the problems are from the 21st century, and they don't really match up. For example, the framers of the Geneva Conventions did not think about the issue. If someone sitting at a computer terminal changes an O to a 0, is that an armed attack? They simply did not think of it because, of course, they did not anticipate the internet. Now, you have a choice. You can either say that because it was not anticipated, this is a black hole. There is no law to apply, and the powerful should do what they can. The alternative is to translate what Montesquieu called the spirit of the laws, to try to understand how the basic principles of the Geneva Conventions should apply from the setting in which it's known to the new setting. Now, I would argue that if there's a very fundamental difference between the Obama administration and the Bush administration, it is this difference. The Bush administration, when it encountered new problems, said that there was law, but it was quaint, and therefore it was a black hole. Where the Obama administration has tried wherever possible to say, let's translate the rules we have to this situation. You may not agree with the way that we're translating it, but we are trying to apply legal rules and trying to obey the legal rules that we understand. Now, the catch is, what are the legal rules that apply to drones? That is a 21st century problem to which 20th century law has to be translated. You could say there are no rules, or you could say here is how we see the spirit of the laws as applying to this novel situation. So my view is that is a world of difference. Saying we're operating within a law-free zone, as the Bush administration often did, or trying, as President Obama has done, to translate. And it encourages people to debate the translation. So my argument would be that this approach explains The legal strategy of the administration demonstrates the value of academic theories and updates 20th century law to address 21st century realities. Now, where did this come from? One of the first speeches of President Obama talked about engaging around our values to make us weaker, and safer, safer and stronger. Secretary Clinton used the word smart power, using the full range of tools at our disposal, not just hard power tools like defense, but diplomacy, development, respect for law, human rights, public-private partnerships. In contrast, the last administration was unilateralist. It did not engage. It was a black hole and did not translate, and it went it alone and did not leverage. So it's a very fundamental difference of philosophy. So how did we engage? And I'm going to move through a lot of material quickly. You can contest each and every one of these examples, but the point that I want to make is this was the strategy. And if you don't like the strategy, you should offer an alternative strategy. I believe that this is the only strategy that we could have used. In some cases, we did not succeed in implementing it fully, but we did approach it with this problem, this perspective. On lawmaking, we found that there were many areas in which we tried to make treaties. Our problem is we did not have enough support in Congress to get a treaty which requires 67 votes in the Senate. You saw how difficult it was for the president to get 60 votes for health care. So our major effort in this area was nominations to international bodies. The International Court of Justice, Joan Donahue we nominated, the International Covenant on Civil and Political Rights, Gerald Newman of Harvard Law School, the Convention for the Elimination of Race Discrimination, Carlos Vasquez of Georgetown Law School, the International Law Commission, Sean Murphy of George Washington Law School, the Mechanism for the International Criminal Tribunal, Ted Marone of NYU Law School. The theory being that filling these positions with American academics who believe in international law would outlive both Secretary Clinton and myself. And it has, in fact, done so, because we're both gone and they're all still there, and will be there for some time to come. How about human rights bodies? The Bush administration had boycotted the Human Rights Council. We re-engaged and were reelected. We did the first Universal Periodic Review. We supported special rapporteurs. We supported working groups. We supported commissions of inquiry. And we used this as a forum to debate difficult issues of free speech versus religious intolerance in the Muslim world, Resolution 1618. With regard to the International Criminal Court, the US had an anomalous position. It had supported international criminal justice at Nuremberg, but it had then adopted a position where it supported ad hoc tribunals but opposed the only standing tribunal. So the outgoing position of the Bush administration was to defeat the International Criminal Court. Unfortunately, we don't have the votes in this administration to ratify the Rome Treaty or to change the laws, particularly the so-called Hague Invasion Act. So we changed the policy 180 degrees without changing the laws. I describe this to my son as turning a car around inside a garage with the doors closed. It's not easy. We engaged at conferences in Kampala, Hague, and New York. We translated to make it clear that we did not oppose the object and purpose of the Rome Statute, thereby unsigning John Bolton's unsigning of the treaty. And now, most strikingly, we support every ongoing prosecution before the International Criminal Court, and in fact led the way for a referral on Libya. So on the one hand, we opposed before all of them, now we support all of them. That's a significant transition. And then on partnerships, the central awareness here is that governmental resources cannot do everything. And so, for example, with regard to conflict resources, everyone knows of the Kimberley process, where multi-stakeholder initiatives are brought into play to address the issue of conflict diamonds. We try to apply that more broadly to the extractive industries, to internet governance, the Secretary of State's initiative on public-private partnerships, and linking development and aid with defense. Now, I want to argue over the next period, and I'll go through these quite quickly, but I'm happy to answer any questions in the question and answer, that this strategy explains the approach in a very divergent group of areas, and I'll end up with war. But I don't start there because people often just ask me questions about tactics as opposed to strategy. So this is designed to elicit questions about the strategy. On human rights, the classic case for me was LGBT rights. Secretary Clinton had a choice. Does she say nothing about LGBT rights, or does she engage? And she chose to go to Geneva and give a speech. What does she say? She translates. Human rights are LGBT rights, she said, or LGBT rights are human rights, in the exact same way as she had previously said at Beijing Women's Conference, women's rights are human rights. She translates into the doctrine of human rights a new set of protected persons. And then we have leveraged this in the administration with domestic initiatives on don't ask, don't tell being eliminated in the military, the granting of same-sex benefits, shifting the position on marriage equality before the U.S. Supreme Court, challenging the constitutionality of the Defense of Marriage Act to be the first U.S. executive branch to be in favor, strongly in favor of LGBT rights. Or take the case of Chen Guangchen. I happened to be in China when this blind activist escaped from house arrest, broke his foot, and got to the outskirts of Beijing. They called me to ask me whether he could enter the embassy. And it was very clear to me that we had to find a legal precedent which could distinguish this from two other cases. Fang Lizhe had come to our embassy for 17 months. Cardinal Mindszenty had come to our embassy for 17 years. And I anticipated that the possibility that Julian Assange would come to the Ecuadorian embassy in London. So the question was, did he have a legal right to enter? We concluded he did not. But what we did conclude was that the United States had a legal right to admit him temporarily for medical care, and that was a sufficient basis for him to enter. So we engaged with him and the Chinese. We translated the rules of entry into the embassy for the purposes of allowing a political settlement. Secretary Clinton appeared and gave us one directive, his wishes, our values, which became the guiding principles. And then we leveraged this with a private institution, New York University, to secure his release. And now he's in NYU. That shows me with him on the day that he arrived. How about Burma? Again, we could have not engaged with either the opposition or the government. Instead, we engaged with both, Aung San Suu Kyi and the regime. We translated a policy which had imposed sanctions into a easing of sanctions policy based on action for action, and have now tried to leverage this with public and private groups into an emerging initiative on rule of law, which Aung San Suu Kyi is leading as chairman of the Parliamentary Committee on Rule of Law. And then the greatest challenge, Arab awakening. There was a moment at an early meeting I attended with Secretary Clinton where thousands of people were in the streets, and somebody said, does anybody see a silver lining in all the people in the streets? And Hillary Clinton said, yes, they do not want to join Al-Qaeda. They want to have control of their own lives and their own countries where they have not had this kind of civic participation for many years. And so she put this in a speech, and example one was Libya. Now, Libya is now thought of as a military operation. It was a smart power operation. We engaged with the Libyans, the Arab League, the Security Council, NATO. We did not assert a freestanding responsibility to protect. We translated that into the notion that Gaddafi had forfeited his responsibility to protect his own citizens, which allowed intervention as a result of 2 Security Council resolutions. We then used military force with regard to a no-fly zone and an arms embargo, but combined it with an assets freeze, diplomacy, travel ban, ICC accountability for the goal of protecting civilians. And with all the difficulties in Libya, it did succeed. This goes to the challenge that we face in Syria, where the engagement continues. Today, Secretary Kerry is with Lakhdar Brahimi and discussing these issues with Putin in an effort to get to a UN Security Council resolution that translates the Libya precedent to leverage it into a ceasefire, support for the opposition, humanitarian aid, securing of chemical weapons, and accountability. We can obviously talk about what should happen next, but that's the central challenge. Or take the Arctic. As time goes on, the Arctic ice cap is melting. What is the governance regime there? The Kyoto Protocol was abandoned. At Copenhagen, the deal was about to collapse. Obama and Clinton together asserted that there should be a politically binding agreement on a global temperature goal. At Durban, this was upped into a so-called agreed outcome with legal force. And then a leverage was conducted by choosing as the governance regime something called the Arctic Council, 8 Arctic states, which is now essentially operating a regime on climate change in which non-legal understandings are layered on top of law of the sea rules. The same goes for the South China Sea. There was an excellent editorial on this in the Financial Times this morning. China is asserting it's a black hole, a law-free zone. What's happening instead on the other side is engagement through dispute resolution before the International Tribunal on the Law of the Sea, an effort to translate law of the sea principles on rocks and islands for maritime entitlements, and to attempt to translate this and leverage it into a regional solution administered by the ASEAN Code of Conduct. The EU is another challenge, because the EU is quite different in the 21st century. So engaging with the EU legal advisors meant my meeting with dozens of people. There are fewer people here than the EU legal advisors. I would meet with the EU legal advisors and say, who is my counterpart? And every one of them would raise their hand. I'm not kidding. A member of every member state had a legal advisor. The Commission, the Council, the Parliament, the External Action Service. Literally, 60 or 70 people need to agree even to get to an EU position, and then they had to agree with us, where we had thousands of lawyers on our side. The translation questions are massive. Is the EU a foreign state for purposes of the Foreign Sovereign Immunities Act? The Cadi case, well known to all of you. What's the relationship between EU law and UN law? The leverage we've tried to achieve here is how to use the growing jurisprudence of the European Court of Justice and the Strasbourg Court to influence US public law. One of the things I pioneered was a very simple thing, the first official meeting between the United States Supreme Court and the European Court of Human Rights. They had never met. Second, the first formal and official meeting between the US Supreme Court and the European Court of Justice. They had never met under official auspices. Some people thought it was because of the antipathy of the justices to each other. It turned out no one had set up the meeting. They don't have a State Department. So I figured that this was something that we ought to do so they could talk to each other. And in one of the briefs that I filed a number of years ago, the US Supreme Court for the first time cited the European Court of Human Rights in the same-sex sodomy case, Lawrence. So when I left the government, we filed a similar brief in the case involving same-sex marriage, an attempt to try to leverage European human rights precedents into US public law. As you see, I get into more and more 21st century issues. A remarkable amount of my time was spent on 21st century families, which are families that are developed not through normal processes of procreation. Take this scenario. A lesbian couple has 2 parents, one of whom is American and the other whom is not. And they choose to conceive by implanting in the womb of the American mother a sperm and egg from foreign donors. Now, under US law, the mother must have a, quote, natural relationship with the child to confer upon that child American citizenship. And the term natural relationship had been construed to mean genetic. And in a long, almost 2-year debate, I argued that natural can include genetic and gestational. And hence the mother could deliver US citizenship to a child that she carried and bore through her own birth canal, even though that child has no genetic relationship to her. This seemed to me like a reasonable translation of the spirit of the laws to a 21st century problem. But it was controversial and remains controversial. And this led me to what I think will be the subject of my major academic research going forward, the human rights of clones. I do believe that this is an issue on which we need to be ahead of the curve. Clones exist, I'm sure, somewhere. It cannot be that the circumstance of their birth will entitle them to a lesser status of rights any more than if they were illegitimates or disabled or homosexual or bisexual. It cannot be that conception by a different method makes them less human. So obviously this runs deep into other issues. When does life begin? What should the human rights of clones be? Should they even be called clones, or should they be called something else? But as you can tell, it's a rich subject for human rights, which very few have tackled. And then cyberspace, and I just give you a flavor of this, is such an incredibly rich environment. One way to think about it is there is no law of cyberspace. After all, international law is territorial, and cyberspace is not. But there are four issues that arose in my time: internet freedom, intellectual property, and piracy, e-commerce, and cyber conflict. Secretary Clinton early on made a speech in which she pointed out that Article 19 of the Universal Declaration, which talks about the freedom to receive and impart information and ideas through any media, was designed to address the kind of technological advances that make internet freedom subject, again, to human rights rules, a translation exercise. On intellectual property, how to work with other countries to protect standards for protecting intellectual property. Online dispute resolution in private international law, how to create a low-cost and efficient method that nevertheless protects consumers. And then cyber conflict. One of the great ironies is that most American military are extraordinarily physically fit, but those who are in the cyber command look like Jack Black, the comedian. I mean, they sit there wearing T-shirts and eating Cheetos, and their fingers fly across the keyboard. Are their actions governed by international law? Well, we thought, because the Chinese were asserting it was a black hole, that we would translate. So we engaged through diplomatic discussion in the group of governmental experts and in the WICIT, the World Conference on International Telecom. We translated the laws of war to cyberspace, and we have tried to leverage it into various standard-setting exercises on cyber war. What about the fact that most 21st century war will be fought by private security contractors who are not subject to governmental supervision? Chris McCrudden has written about government procurement, both of goods but also of services. And the obvious question here is engage by a code or a statement of principles called the Montreux document, translate into a code of conduct that has public and private stakeholders, and then leverage by inserting these standards into private contracts to try to internalize these norms into the behavior of private contractors. Which brings me now to Al-Qaeda and 21st century war. How do you adapt the smart power approach to counterterrorism? Last week, President Obama made a major speech on this. The big news should have been, it was old news. Secretary Clinton, in September 2011, sketched this exact approach, where she said, for the long term, we need to use force for limited and defined purposes within a much broader smart power framework: diplomacy, development, education, people-to-people outreach, winning the hearts and minds of moderate Islam. But in the short term, there is no alternative to precise and persistent force to eliminate the most radical and extreme networks. Which suggests that the drone debate is about a tool, not a strategy. The strategy is to engage with our allies, to translate legal rules to a new setting, and leverage this with other tools to achieve a better outcome. Now, again, this is a contrast to the last administration's approach. What President Obama said this past week: we must define the nature and scope of the struggle, or it will define us. And then I think most fundamentally, he said, we must not have a perpetual war. This war must end. And therefore, he would repeal and replace and not expand the authorization for the use of military force. He pointed out that we are not fighting a global war on terror. It's an effort to dismantle specific terrorist networks that threaten the United States, principally al-Qaeda, and that drones he defended, as applied, not in all circumstances, but as applied, as an effective discriminate tool to be the least bad way to conduct what he called the just war as part of this approach. So again, the differences are not a global war on terror, not a black hole, an absolute insistence on humane treatment, and applying facts, not labels. The issues going forward are transparency, consultation, standard setting, and ending war. Let me mention those quickly and then conclude. On transparency, finally last week, President Obama acknowledged killing Americans and releasing facts and a legal explanation. He began a process of consultation with Congress and allies, and he sets forth standards that the White House has institutionalized in presidential policy guidance for how to deal with drone strikes and discuss these standards with our allies. Some of these are also set forth in some articles written recently by former British legal advisor Daniel Bethlehem. The guidance, according to the press, raises the standards for striking targets to a continuing imminent threat, requires near certainty of the identity of the target and also avoiding civilian casualties, shifts the responsibility to the Pentagon with a review period, and defines the war and the enemy narrowly to include al-Qaeda, the Taliban, and associated forces. And the importance of this became clear in two recent incidents, Boston Marathon and Woolwich, where even though the individuals were sympathetic to al-Qaeda, it's quite clear they were not members of al-Qaeda or co-belligerents. They simply drew inspiration from them, and therefore they should be the subject of law enforcement, not the law of war. You put this together into a general smart power approach to ending the other two wars in which the U.S. is engaged with Iraq and Afghanistan, through declining military engagement, continued civilian engagement, developing civil society, and enhanced diplomatic engagement. And you see that the goal of the Obama administration is to end the wars it inherited. Now, Guantanamo is an example where they have, to this point, announced a posture but not succeeded. But if you say that the war must end, the legal authority to detain will end, which sets a time limit on how long Guantanamo can be a lawful situation. And so President Obama announced 6 steps last time, and now needs to put his political weight behind them to make them succeed. There are many challenges going forward. We can talk about these in the Q&A. Will there be an expanded authorization for use of military force? The president said no. When is self-defense called for? What proof do you have of sovereign consent? Should there be independent review by a court or internal executive process? How to make peace with the Taliban and how to deal with self-radicalizers. So I've come through a lot. I hope you come to the conclusion that I did. Academic theories can be relevant to government lawyering, and we can develop a legal strategy, which is smart power, and that engagement is nothing other than interaction, translation is nothing other than promoting interpretations, and leverage is nothing other than internalizing rules into a regime. It's both an academic theory and a strategy for action by both governments and NGOs, which was the philosophy by which we tried to do things while I was there. It explains our strategy, tests our theory, and translates law and theory to 21st century realities. It fits with the notions that I expressed that this strategy can be a strategy for positive engagement where the U.S. can lead through legal compliance, internalize respect into government practices, and lead to a better relationship with other international partners. And finally, this is not Grotius's international law. It's a new kind of international law, which students of international law in this century will have to deal with. How to engage around our values using new tools, how to translate 20th century laws to 21st century realities, and how to leverage law as a tool of smart power. I see this as my project of the last 4 years, but also of the next however many years. Because it seems to me to elaborate and improve this will be a challenge for many of us, and it's something to which I have now committed myself and look forward to doing so. I hope it will lead to conflict transformation. I hope it will lead to social justice, and I hope it will lead me and my family to many more trips back here to Belfast. Thank you.